Good day. My SRN is 104937-2. I repeat, 1049372. That is my SRN. My name is Gabriela Fajardo Palacios. I am a trainee solicitor at the fictitious law firm Brierly Bond. My supervisor, Marcus Evans, has asked me to advise our client on a family matter, Mr. Raj. First of all, I will commence by defining marriage. Validity of marriage. How can marriage legally end? Alternative both parties can consider. Orders the court will consider. Remedies the court will give regarding finances. I will start by defining marriage. Marriage is the voluntary union for life of one man and one woman to the exclusive possession of others, I beg your pardon, as in Hyde and Hyde 1866. Elements to consider are the age, prohibited degrees of relationship, already married, and mental capacity. Capacity is seen in section 1.3 and Schedule 1 of the Marriage Act 1949 and Section 11 and 13 of the Matrimonial Causes Act 1973. There are formalities to marriage. There are 3 categories and the formalities of marriage. The first category is the preliminary procedure, the second, ceremony, and the third, registration. Family assets, the entitlement to family assets. There are 2 types of family assets which are our client is entitled to. We shall see which one is relevant and applicable to your situation. But I would just run brief through them. The ones that are, and that is resulting trust and constructive trust. Resulting trust can come into existence in 2 ways. The first limb of resulting trust is property purchased in sole name of A, in this scenario is Mr. Raj, and B, Mrs. Selma, who make financial contribution to the purchase price, other deposit, legal fees, etc. The presumption of beneficial interest is proportionate to financial contribution. The second limb to this resulting trust is the property purchased in joint names. Without reference to beneficial interest, presumption that beneficial interest will be held jointly. Now let's consider constructive trust, and this is defined in the case of Lloyds Bank PLC, Russell 1990. There are 2 types of agreement. Evidence of express agreement to share property beneficially. Second limb is no evidence of an agreement, but conduct of parties infers a common intention to share property beneficially. So those were the 2 financial entitlement assets. Divorce. Under Part 1 of Matrimonial Causes Act 1973, there is one sole ground on which a petition for divorce can be brought: that marriage has irretrievably broken down under Section 1.1 of the MCA 1973. In order to prove this, the petitioner, in this case, Mr. Deepak Raj, must show the existence of one of 5 facts which are under Section 1.2 of the MCA 1973. The following will be the 5 facts. The first fact is the respondent has committed adultery and the petitioner finds it intolerable to live with respondent as seen in Section 1.2a of the MCA 1973. Second fact is that the respondent behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent, in this case Selina. The relevant statute, Section 1.2b of the MCA 1973. Second fact, the respondent has deserted the petitioner for a continuous period of at least 2 years immediate preceding the presentation of the petition, as in the Section 12C of the MCA 1973. 4. The parties to the marriage have lived 2 years immediately after the immediate preceding the presentation of the petition, and consents and have responded. Sorry, let's go back. Let's understand this. It says that the parties to the marriage have lived apart for a continuous period of 2 years immediate after preceding the presentation of the petition, and respondent consents to a degree being granted. Oh, that is in section 12D of the MCA 1973. I will explain in more detail the relevant fact which is applicable to Mr. Deepak Raj's scenario situation. The last fact is that the parties to the marriage have lived apart for a continuous period of at least 5 years immediate preceding the presentation of the petition, as seen in section 1(2)E MCA 1973. Divorce procedure in brief. Mr. Deepak Raj may use the special procedure which will enable both him and Selina to obtain their degree without the need to attend. Mr. Deepak Raj will be required to file at court the divorce petition to which the respondent Selina files a response. If there is no question of a defense or cross petition, the petitioner also swears an affidavit as to the evidence relied on to prove the irretrievable breaking down of the marriage, and one of the facts from section 1(2) of the MCA 1993. If the judge is happy with the nature of the documents and the evidence in the petition supports the fact, he will grant a decree nisi, and thereafter petitioner can seek the decree absolute to finalize the divorce. Alternative, Mr. Deepak Raj may resort to mediation, which is the new divorce process under the FLA 1996, and the intention to reduce the harmful and distressing effects of divorce. This is not the same as reconciliation, because this method process focuses on helping move forward into life as people as divorced individuals. Financial orders available to the parties. Capital orders, property adjustment order, and pension orders. Let's start with capital orders. This is in section 23 of the MCA 1973, where an outright transfer of a lump sum of share or installment payments will permit that control. The court may order sale of Mr. Raj's property to allow a capital order to be made. Property adjustment order, seen in section 24 of the MCA 1973. With this order, the court may order the sale of the house and divide the proceeds between the parties to enable them to purchase individual properties. Pension orders. Under section 24B, C and D of the MCA 1973, the court could attempt to compensate Selina, who's risked the loss of petition benefits at the end of the marriage, if there is sufficient resources available to do so. In the situation, Mr. Raj, Mr. Raj is a high income earner, and the court will definitely consider this order to bring a solution to the situation, an equal solution to the situation. In conclusion, Mr. Raj, under law, his marriage is valid as both parties were of capacity of age and both gave a valid consent to the marriage and were not under threat when marrying. Thus, the marriage cannot be considered voidable or void because there is no pregnancy of third party, even though Selina, the respondent, had committed adultery. Thus, this leads Mr. Raj, however, to consider petitioning the court for divorce. Adultery. Let's define adultery now. Adultery is defined by voluntary sexual intercourse between a married person and a person of the opposite side sex who may or may married and who is not the other person's spouse. The act must be voluntary. That is illustrated in case law Redpath and Milligan 1950. The degree of sexual intercourse required for adultery is that some degree of penetration is achieved. That is illustrated in Dennis 1955. This can be compared with the degree of sexual intercourse required for consummation, that is ordinary and complete. Intolerability. Adultery is considered to be a serious matrimonial offense, and as such a standard of proof higher than the normal civil standard of proof is required. The case that illustrates this is Bostable and Bostable 1968. The subject test can be satisfied by asking the petitioner, in this case Mr. Raj, to see if he finds it intolerable to live with the respondent, as in Clary and Clary 1974. Under Section 2.1 and Section 2 of the MCA 1973, reconciliation provisions are available. It says that cohabitation over 6 months after becoming aware of adultery destroys the fact. However, Mr. Raj, in present case, he has tried to reconcile for 2 weeks with Mrs. Selina, which shows under the law that there was a degree of uncertainty and unwillingness to proceed with marriage, and this does not destroy the fact of adultery. Also, a clean break will be considered because there are no children involved. The clean break principle is seen in Section 2.5a of the MCA 1973. The idea behind the provision is to bring to an end any dependence or obligation between the parties as soon as is practicable, depending on the circumstances of the case. Illustration are seen in Sutter and Jones 1987. Divorce may be acquired by 2 options: the special procedure or mediation. The relevant financial orders available to Mr. Deepak Raj are under Section 23 and Section 24 of the MCA 1973, which are capital orders, which the court may consider for the sale of the large house, and a property, and the second order is the property adjustment order for a fair considerable share of assets for both Mr. Deepak and Selina. Having just explained all that, I have identified that constructive trust applies to Mr. Deepak Raj's scenario, because the court will say Selina, by considering and working part-time, thus agreeing she could renovate and run the house, was contributing to the assets of the matrimonium, even though it was in Mr. Deepak's Raj's sole name, the large house. The law sees both parties as one entity. That was all the relevant information I have gathered and researched for the current for our client, Mr. Raj. If there are further questions regarding this presentation or this work, could you kindly email us, and we'll surely reply back with a good response. Thank you very much.